15.
Wait, page 57.
Yes, 57 and 58, as well as 59, page 59.
Okay. And which date?
On the 21st of November, 2024. Yes. And my lord, the sole issue why we canvass or we re-examine Brigadier Gininda on section 105 was to demonstrate that it is the defense that elicited this information, and that despite Brigadier Gininda sounding a word of caution that he may not traverse the issue of section 105, that the defense of their own bet pursued this line of cross-examination. Now, yesterday, Brigadier Gininda explained the import of section 105A, and we're not going to take it further than that, my lord. The law regarding section 105A is very clear that once the negotiations fall through, that no further reference may be made to those negotiations. And we just wish to draw the court's attention to page 58 of the proceedings of the 21st of November 2024, where Brigadier Gininda on page, in fact, starting on page 57, line 20, Advocate Nisi says, thank you. Now I just want to paraphrase what we have just said now so that I'm able to follow you, and the rest of the discussion follows. But what we want to focus on, my lord, is page 58, the answer by Brigadier Gininda that the discussions was insofar as I am capable to go there, my lord, because I was told by the prosecution that because those discussions in terms of section 105A were not finalized, one should not venture into that. We just wanted to place that on record through the examination of Brigadier Gininda.
No, but how was the question posed to elicit the answer?
Yes.
Which you say Brigadier Gininda proffered.
Yes. So we're not going to take
No, how was it posed?
Yes.
Did it make reference to 105A?
Yes. It starts on page 57, my lord, by Advocate Nisi on the 21st of November 2024, line 20. Mr. Nisi, thank you. Now, I just want to paraphrase what you have just said now so that I'm able to follow you. You are saying on the 23rd, there was a discussion between accused's attorney and himself with the prosecutors for a confession that was supposed to, or about a confession that had to be taken at 24 June 2020. Not so. Then Brigadier Gininda then gives the answer that I've just placed on record. Then Advocate Nisi proceeds on page 58 at line 20. Now, on the 16th, accused to get arrested by Mohani and Mabena. On the 18th, as per your version, you are meeting him at Carltonville, where you hear that, where you heard, or should be heard, where you had that interview with him. On the 19th, he appears before Rapadu, 19th June 2020. He appears before Rapadu for an alleged confession. On 23 June, there is an attorney, there's Mr. Mjiako, and Mr. Mjiako now appears at the scene or in the act, and there are those little arrangements that we have discussed about the possible plea bargaining arrangement and the confession. Now, this was after Brigadier Gininda sounded that word of caution. And furthermore, on the same page, my lord, at line 21, Advocate Nisi says, maybe before I proceed, on 23 June, when there was this attorney, Mr. Mjiako, made an arrangement with the state with regard to a possible plea bargain and a subsequent confession. Were you part of the discussions? This is the information, my lord, that we, through re-examination of Brigadier Gininda, that we wanted to put on record. Thank you. Then the second issue, my lord, is regarding the state re-examination of Brigadier Gininda on the additional photos that were downloaded on the cell phones of accused number 2 and accused number 3. There was an objection by the defense, and the state wished to then deal with that aspect, my lord. And to that end, we've prepared brief heads of argument to deal with those aspects. My lord, in the introduction, paragraph 1.1, we mentioned that the state is currently busy with the
kade khona ke indaba kakhuluma ngayo ke okumele ihlangothi elethimba labeshushizi lana ke udaba lokuthi kade khona ke inkulumo kade khona iqhamukile ngesikhathi esimsolo qala bahlangana khona ke nofakazi uBrigadier Gininda lapho ke la ithizini ngaphambi ukuthi enze confession futhi ukuthi enze ke isivumelwano secala ke lapho ke ngesikhathi ade behlanganele bonke kushuthi lapho ke isivumelwano ukuvuma icala noma isivumelwano secala ke lapho ke esiwela ngaphansi komthetho ka section 105 ke lapho ke la kade khona bathi lakhuluma ngodaba lokho ukuthi bona ke beyafisa ukuthi babuze ufakazi malana nemibuzo eqhamukile kulolu daba lokho bese bathi ke ngembangelo ukuthi lokozana ke isivumelwano leso singakaze senzekeke akumele ukuthi baqhubeke babe sebabuza imibuzo kulolu hlangothi lolonke manje uyasho khona ukuthi khona ke inkulumo ayibhalile ethe wayilungisa ke lapho ke malana nodaba lezithombe ke lezi abayijobelele ngaphakathi kwezithombe lezi bekuvele sezikhona ke ithombe esiqwa khona ke lapho ke umsola wesibili ke futhi nomsola wesithathu ke athi khona njalo ubhale inkulumo lena ngoba ufisa ukuthi ayifundele inkosi enkantolo ke ngoba athole ke bese ngemuva kwalokho athole ke ushuthi isicelo sakhe ke lesasibhalile bese ngemuva kwalokho athole mhlawumbe ukuthi inkosi enkantolo yakuvuma yini ekuthizini aqhubeke abuze ufakazi ngemibuzo ngodaba lezithombe ade lokhona ke phakathi kocingo lakwamsola wesibili futhi nomsola wesithathu.
Now in paragraph 1.1, my lord, in the introduction we mentioned that the state is currently busy with the re-examination of Brigadier Gininda, and we seek to re-examine him on certain additional photos of accused number 2 and 3 that were extracted from their cell phone downloads. And we mentioned, my lord, that the sole purpose of such re-examination is to put a full and fair picture before the court to enable the court to adjudicate on the issues that are in dispute, namely the identity of the perpetrators who invaded the Kumalos home on the 26th of October 2014 and killed the deceased. It is our submission, my lord, therefore, that the evidence is relevant. In paragraph 1.3, we mentioned that the defense has raised an objection against this evidence on the basis that it is new evidence that was not canvassed during cross-examination by defense counsels.
Bekafuna ke mana lo daba lencwadi kayibhalile lapho ithizeni kusenkantolo emvumela ithizeni abuzeke ufakazi babo Brigadier Gininda ke imibuzo mana nodaba ithombe lezi ethize bazijobelela ke kuyithombe kade zikhona ke qhawe isithombe zalapho ke zakamsolo wesibili futhi nomsolo wesithathu athi khona ke lapho ke usuthi uma iqala ke inkulumo yakhe lapho ke ngaphansi kodaba loqala athi bekacela futhi bekathanda futhi uyazi ukuthi khona ke njalo ubaba uBrigadier Gininda uyena ko ngaphansi kwesifungo njengamanje ke futhi bekathanda ukuthi kambuze aqhubeke futhi ambuze ke imibuzo mara nodaba ithombe lezo thize basijobelela lana kule icala leli ke ephecelezi equka khona kumsolo wesibili futhi nomsolo wesithathu ke ithombe lezo bazithubulile ucingweni noma kumakhala kukhwini wabo ke yasho kwazi ukuthi imbangela noma inhloso ukuthi benze lokhu ke ukuthi afuna ukuthi icala leli ke lehlale kahle phambi kwenkantolo futhi ngendlela ejwayelekile futhi ngendlela eqondile mayelana nodaba lokuthi lapho ke basho khona ke abantu abangena ke ngaphakathi kwalomuzo kaKhumalo ke ngelanga la nge26 kaOctober ngomnyaka 2014 bese babulela khona ke lapho ke umufi waqhubeka washo kwanza wathi lokhu kubulungiswa mhlawumbe ufakazi obukhethekile futhi obuhambisana necala leli ke washo kwanza wathi kepha ke ihlangothi noma ithimba ke labameli ke likunqabile ekuthizeni bona baqhamukise ke ithombe lezi ke ngoba wathi ufakazi obusha ke lobo futhi bona abakaze bakhulume abakaze bakhulumisana ke ngodaba lolu.
Now, my lord, we contend that the issue of identification and description of suspects was canvassed in cross-examination, and that insofar as accused number 3 is concerned, his counsel did traverse the issue as to the appearance of accused number 3 on page 87 of the record of the 29th of November 2024, and we quote the relevant passage where Advocate Nisi states as follows. Thank you, Brigadier. I will not take issue with the usage of terms like identification and description. At least now you are explaining it, that you actually meant to say description. But when I read it, I said identity. Identified means you just go and have a common thing, like to go and point it out. Do you understand? But thank you for the explanation. It eases my mind. Then Mr. Gininda understood, my lord. Advocate Nisi, thank you. Now let us proceed. Photos downloaded, taken of the accused by himself, and in brackets, selfies match the description of the suspect who had the firearm with dreadlocks, big eyes with gold teeth. Let us pause there. Then Brigadier Gininda, yes, my lord, I'm listening. Then Advocate Nisi, thank you. Now let us go to I think it is Exhibit S, the downloaded pictures. Brigadier Gininda, yes. Advocate Nisi. Just of the downloaded, yes. Now I'm going to request you to meticulously go through Exhibit S. As I told you initially, sir, that this is an affidavit, and you really would understand better as a manager in subs what an affidavit and what it is, and that is being said in an affidavit entail, and what is said in the affidavit entail. But having said that, let us go to Exhibit S. You take us through those photos, those downloaded photos that were taken by the accused himself with dreadlocks, big eyes, and with golden teeth. And we have bolded these portions. We can request the state to page for us so that the accused persons can also follow. Start with the first picture. Now, these pictures of accused number 3 that we seek to re-examine Brigadier Gininda on talk to this description that Advocate Nisi is touching on here. Then Brigadier Gininda answers, yes, my lord. So which part do you want me to describe? All the pictures that are now under this exhibit. Then Advocate Nisi, okay. let me leave you to do your own identification of the picture that has the accused, that has the suspect who is now said to be accused 3, and we've bolded that portion, with dreadlocks, big eyes, and with golden teeth, from the downloaded pictures as information that you told the magistrate. Then Brigadier Gininda. Yeah, so my lord, firstly, so I will identify those pictures, but firstly remember, sorry my lord, my apologies, what I wanted to say, this is summary, and we close the quotation. Now, insofar as accused number 2 is concerned, the issue of his identity was canvassed as follows by Mr. Ramusepeli on the record of 30 November 2024 at page 63. He says the identity kit was compiled. Makalani is the only person that gave the description of suspect B. Then Brigadier Gininda, my lord, if I can just have a second, I just want to check something, a second or two. Then Mr. Ramusepeli, I can quickly assist you. The first witness is Ms. Kelly Kumalo. If you look at the last 2 sentences, she says, Mrs. Steenkamp, Kelly Kumalo could not describe the second suspect. Do you see that? Brigadier Gininda, yes, I do see that. Then Mr. Ramusepeli, yes. Then Brigadier Gininda, and we've bolded the response of Brigadier Gininda. That is exactly where I wanted to go in terms of describing or could not give the profile. But as I said, you take this in relation to the statements as well. Because in the statements, as much as they are not giving marks in terms of their identity kit that was compiled by Warrant Officer Steenkamp, but they do indicate more or less how the second intruder was. But insofar as the compilation by Warrant Officer Steenkamp, yes, we are in agreement. They did not say it, but insofar as their statements are concerned, they do give an indication as to how the second suspect was looking like and what he may be carrying. We therefore submit, my lord, that the identification and description of the suspects who intruded the Kumalo's house on the 26th of October has been the main focus of the cross-examination of Brigadier Gininda, and therefore falls within the ambit of Section 1661 of Act 51 of 1977 as being, and we quote, any matter raised during the cross-examination of that witness. We close the quotation. We contend, my lord, that as these are photos of accused number 2 and 3 that relate to their appearance and will assist the court in adjudicating the identity of the assailants who barged into the Kumalo's home on the 26th of October 2014, the photos will serve to put a full and fair picture before court. Then paragraph 1.5. In the alternative, my lord, we submit that even if the re-examination of Brigadier Gininda on these additional photos can be regarded as new matters that do not arise out of cross-examination of Brigadier Gininda, we submit that the new evidence can still be canvassed with the leave of the court, and the court may allow further cross-examination on the new evidence. And in this regard, we refer to the well-known Handbook of Detoy and others, Commentary on the Criminal Procedure Act, the 2024 edition, pages 22 to 96. And furthermore, we make the submission that should such evidence be regarded as CSA evidence, the Hearsay Act does allow for provisional admission of hearsay evidence subject to the downloaders being recalled.
Kade yasho khona ke njalo ihlango thuma ithimba labashushisi ke lapho likhona ngodaba lolwethombe phecelezi ithombe lezi equka khona ke lapho ke umsola wesithathu ke lapho ke futhi yasho khona ukuthi mangabe bekhuluma ngodaba loluke udaba loluke athi balukhuluma ngesikhathi sade bebuza ke imibuzo ke abameli benu la ngaphansi kwenkantolo qhubeka yasho khona ukuthi lapho ke uma bebuka lapho ke malana nelanga noma ngoba nenkulumo ekhunywa ngelanga la nge-29 November ngomnyaka 2024 ukuthi uadvocate umnisi lapho wathi ngiyabonga brigadier angeke abesahambela emathi ke noma nodabaluke malana nendlela kade bemchaza ngayo ke umuntu noma kade emkhuluma ngayo umuntu noma isikhangiso somuntu kade khona ke lapho ke wathi ke mangaba uma angaqhubeka futhi asho khona njalo ke manje amaphuzu akhe futhi yazwisisa ukuthi lokho mhlawumbe ufakazi angabeka akukhuluma ngokwakhe ke wathi ufakazi yebo ngiyabonga futhi athi singaqhubeka lapho ke uma bekhuluma nodaba lwethombe bakhuluma khona ngomalana nodaba lwethombe zakamsolo wakhe lezi umsolo ayithathama yena ke mathupha ngokwakhe futhi selfie ithombe ayithubula ephethe ucingo lwakhe futhi sekathatha ithombe mabamba ucingo ngalendlela elandelayo bathi mhlawumbe befoni ngalendlela bese uthatha ithombe lapho ke isikhangiso leso basibiza ukuthi uselfie ke lapho ke bathi umuntu leke wena umuntu wangena ngaphakathi kula khaya lomuzi wakwakhumalo ke lapho ke ephethe ke isibhamu kena ke futhi kade yana amadress kena ke futhi bakana mehlo amakhulu futhi bakade nezinyo legolide la kena ke kumazinyo akhe ke bese wathi brigadier Yaginenda yebo ngilalele ke Nkosi enkantolo mayiqhubeka khona ke njalo mayiqhubeka khona njalo inkulumo khona ke sengaphambili ke bathi abakhe babukeke ithombe kade zingaphansi kwemibukiso kaSK lapho ke ngesikhathi kade bedownloadile ithombe zakhona bathi ubrigadier Yaginenda yebo uyezwa lapho ke wabe khona njalo bese waqala ke lapho bayidownload bese waqala wathi yena ke athanda kamceleke uthi akhuluma phecelezi ngethombe lezi ezikhona ke lapho ke ngaphansi kwemibukiso kaS lapho ke athi yebo ngiyakuzwa ke mhlompheki noma ke mnomzana uma bebuka ke ithombe lezo shuthi bakhulu isithombe kade bezibhaliwe lapho ke noma kade zihambisana nodaba affidavit ke lapho ke ithombe zathi bethule ngaphansi kucingo lolwakamsolo wakhe noma lo muntu bathi bakana ama-threats futhi anamehlo amakhulu futhi nezinyo legolide ke kena ke futhi bathi ithombe lezikhona ke ngaphansi koshicilelo noma ngaphansi kobufakazi ade bukhona ke la ngapha noma ngaphansi kwemibukiso ubufakazi ade bukhona ke lapho ke wathi bese wathi umnomzana omnisi yena kuyakuzwa ke lokho ke kepha yathanda ukuthi ufakazi buye ke osikhokhelayo noma kulolu daba lokuthi asitshele balana nalomuntu othizeni ade besola ukuthi umsola wesithathu ke lo muntu loyo ke futhi kade nama-address ke kena ke futhi anamehlo amakhulu futhi nezinyo legolide kena ke bese wadownload ithombe zakhona bese bazidlala ngaphambi kwenkantolo ke lapho ke wathi yebo ngiyakuzwa kepha khumula khona njalo bese ufakazi wakhuluma khona lapho ke wathi yebo ngiyakuzwa kepha kuma sesikhuluma ngedaba lethombe lapho ke into ekhumula ukuthi lapho ke bese wathi uyaqolisa ke lapho ke waqala futhi ngenzansi kancane nje ngokugcwele ke noma mhlawumbe uma sekasamaraza ke inkulumo yakhe lapho ke washo wathi khona uma ngabe sikakhuluma ke ngomsolo wesibili ke lapho ke lecala leli ke lapho ke bese nje wakhuluma ngodaba lwakhe ke lapho ke ngesikhathi Mr umnomzana Ramsipile bekakhuluma ngelanga la nge-13 zakaNovember ngomnyaka 2024 uma ngabe ubuka ke inkulumo yakhe kwikhasi le-63 ke lapho ke kulaba khuluma khona ke ngale kit begcwalisile ke thombe lapho ke bagcwasa ke lapho umnomzana uMakeleni ke umuntu wakhona ke futhi wachaza nesikhangiso salabantu laba ke okhona ke lapho ke usuthu umsola wesibili ke lapho suspect B ke lapho ke bezathi ubrigadier Yaginenda lapho yebo Nkosi enkantolo ngiyakuzwa kepha kuba ngathola nje umzuzu odwa ke ekuthizeni ngibheke lokho okulandelayo nomhlanje imizuzwana emibili ke lapho ke bezathi umuntu Ramsipile yebo mina ke kepha ngiyakusiza ngokusheshsha ke lapho ke ngoba khumula khona njalo ukuthi ufakazi oqala ke lapho ke ukheli Khumalo akakaze ke akhona ukukhuluma ke ngendlela uma busubukabe lapho ku sentence lama sentence akamabili ke kade abhale lapho uStian Kambu ukuthi akakaze asho ke indlela umuntu wesibili bekajangala ngakhona bese isikhangiso solomuntu wesibili ke athi yebo ngiyakuzwa futhi washo khona njalo ngabe siyaqeda ke inkulumo yakhe wathi lamagama kahle kahle bekafisa ukuthi awakhulumela malana nesikhangiso salomuntu ngoba uma sabheka lapho usuthi profile yakhe lokho adazama ukuveza noma ukusho mana nodouble statement lapho ke ngoba khumula khona nje statement lesingesikhathi ade sibhala lapho kumnumzana noma warrant officer Stian Kambu ngesikhathi bekabhala lapho akakaze asho noma washo lokho kulandelayo ukuthi lapho ke nanoma nake akakaze athole ke lokho ukugcwele malana nodaba lwakhe ke futhi akuvumelana naye futhi ahambisana inkulumo yakhe ikhona ke ummeli ke lapho ke kepha washo ukuthi uma ngabe ungaze ubuke lapho ke malana nethombe zamsolo wesibili ukuthi wathi akakaze kangene ke lekhaya leliyana waqhubeka washo khona njalo inkulumo yakhe ukuthi uma ngabe ke bebheka lapho ke izithombe lezike eziwela la ngaphansi kwemibukiso kaS lapho ke ukuthi ithombe zichaza ke abantu abangena ngaphakathi kolomuzo kaKhumalo ke ngelanga la nge-26 October ngomnyaka 2014 ngesikhathi sathi bengena ke lapho ke futhi ubrigadier Yaginenda wakhuluma ke malana nodaba lolo ke bathi likhona ngaphansi komthetho section 166 subsection 1 act 51 of 1977 ukuthi lo daba lula udaba ke olusha ukuthi bangaqala ke baliveze ngaphambi kwenkosi yenkantolo ngoba sile bakhulumile ke ngalo futhi bathanda ukuthi bakhulume ngamaphecelezi nezithombe zakamsola wesibili futhi nomsola wesithathu ke lapho ke lathi bekhuluma khona ngodaba lwakhe noma ngokuthi ke yibona abantu abasola ukuthi bangena ngaphakathi kwaleli khaya noma kwikhaya lomndeni wakakhumalo ngelanga la nge-26 zaka October ngomnyaka 2014 ngoba kade bebachazile ngesikhangiso sabo futhi ngendlela ababonakala ngayo noma ngendlela abatshengakala ngayo ke lapho ke waqhubeka washo khona wathi lo daba asukuthi udaba oqala nje amathi njengamanje nje ukuthi balikhulume futhi sele balikhulumile ngaphambili futhi washo khona ukuthi umthetho uyavuma ngaphansi komthetho futhi wazogcina ubukisa ngecala ke lapho ke icala lapho la kaDutoti futhi nabanye ke lapho ke elwela ngaphansi komthetho futhi icala ukuthi umthetho omusha ke abaqhamkisile ke lapho ngomnyaka 2024 usuthi uma uka kwikhasi la khona ke les22 kuze kufince kwikhasi les96 kula ubona khona ke malana nalo ufakazi athanda ukuthi abuqhamkise ukuzana ithimba labashushisi ukuthi lecala la kaDutoti lahambisana necala lakhe azama ukuthi noma afisa ukuthi aqhamkise ngaphambi kwenkantolo futhi ashikwenza ukuthi inkulumo abayizwayo ukuthi ke ivumelekile ukuthi inkosi yenkantolo iyamukele esikhathini samanje kuze kufince la bathola khona ke ufakazi ogcwele ngesikhathi leso.
Now, in paragraph point number 2, we briefly deal with the legal position regarding re-examination, and we refer to the case of S versus Ramolope, 1995-1, SACR 616, that is the decision of the now Supreme Court of Appeal, and we just wish to refer to on page 5 of our heads, the third paragraph, starting with the words, as far as the right to re-examine a witness is concerned, the operative words in section 166(1) are on any matter raised during the cross-examination of that witness. And paragraph 4 says 2 points emerge from an analysis of the quoted words. First, there is a statutory right to re-examine on any matter if it is raised during cross-examination. Then the court went on to look at the definition of the words, and it held as follows. These are words of very wide compass, any being a word of wide and unqualified generality. Secondly, the right to re-examine a witness on any matter is only limited to the extent that it was a matter raised during the cross-examination of that witness. The contextual meaning of any matter raised during cross-examination of that witness cannot, in my view, reasonably lead to misunderstanding. Raise means to bring up a question or point, to bring forward a difficulty, objection, etc., to advance a claim. And we wish to then refer to page 6 of our heads, my Lord, the second paragraph, and this talks to the purpose of re-examination. The Supreme Court of Appeal summarized the purpose of re-examination as follows. Generally speaking, the object of re-examination is to clear up any point or misunderstanding which may have occurred during cross-examination, to correct wrong impressions or false perceptions which may have been created in the course of cross-examination, to give the witness a fair opportunity to explain answers given by him under cross-examination, which, if unexplained, may create a wrong impression or be used to arrive at false deductions. And in the following, my Lord, we emphasize this object of re-examination to put before the court the full picture and context of facts elicited during cross-examination, or to give the witness an opportunity to correct patent mistakes made under cross-examination. And what is important, my lord, the court said that these examples of the object of re-examination are not intended to be numerous clauses. Re-examination can be and frequently is a very important mechanism for presenting a full and fair picture of the evidence of a witness and thus of arriving at the truth. That is, my lord, what we're trying with the current exercise that we've embarked upon with Brigadier Gininda. Of course, if counsel wishes to deal with new matter that is not arising from cross-examination, he requires the leave of the court to do so, and this is the request that we're making in the alternative, my lord, that should this additional photos be regarded as new evidence, we request the leave of the court to canvass them with Brigadier Gininda. Then in point number 3, we deal with the reason why the evidence was not led in examination in chief. And 3.1, we point out that the reason why the evidence was not presented during evidence in chief is that it was only during the long adjournment that was afforded to Advocate Nisi to prepare his cross-examination that the state was able to go through the over 700 photos of the downloads, and that a disc concerning these downloads was given to the defense some time ago. We surmise that it was in 2023, subject to correction. The state has now extracted 3 additional photos from the cell phone downloads of accused number 3 and 16 additional photos of accused number 2 that we want to show to the court. We mentioned, my lord, that accused number 2 and 3 do not dispute that their cell phones from which the downloads were made, that these cell phones belong to them. The photos belong to accused number 2 and 3 and therefore fall within their personal knowledge. And in paragraph 3.2, my lord, we make the point, as we did yesterday, that a witness can give viva voce evidence and also use photos to demonstrate his evidence as real evidence. Now, lastly, we deal with the interest of justice. In paragraph 4.1, we submit, my lord, that it is in the interest of justice to allow this evidence, as it will assist the court to adjudicate on the issues that are in dispute, and that the evidence is therefore relevant. Paragraph 4.2, we deal with the locus classicus of R versus Hepworth, 1928, AD 265, 277, that has been repeatedly referred to during these proceedings. Namely, that criminal proceedings are not a game in which one side is entitled to claim the benefit of any omission or mistake made by the other party. The duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice was done. And we refer to the case of Sheikh and others, the reference is there, where the court held that the applicants stress that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35, 3A to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused as well as those distressed by the audacity and horror of crime. And we also refer to the case of MultiChoice and others versus the National Prosecuting Authority. And we just want to refer the court on what is stated on page 8 of our heads, where the court referred to the case of Zukuza and others, and held that the right to a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And lastly, we refer to the case of Dlamini and others. The reference is given there where Judge Krichler in the Constitutional Court described the phrase interest of justice as a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore respectfully submit, my Lord, that the state be allowed to re-examine, sorry, there's a typing error there, to re-examine the witness on this additional photos. Well, before I sit down, I just want to mention that there's another aspect, and we just deem it appropriate maybe to bring it to the court's attention at this point so that we don't argue these matters piecemeal. There's a footage that the state is waiting for from ENCA regarding the proposition that was put by Mr. Mgomezulu to the witnesses, namely that the deceased was shot by Mr. Longwe Twala, and that in the process he shot himself in the foot. There's a footage that is available, my Lord, that we want to show to the court. We have started this process since December of 2024 to obtain this footage, but you know there's a certain procedure that is involved. There's an agreement that was entered with the South African National Editors Forum, SANEF, in terms of which the permission of the Director of Public Prosecutions must first be sought before a subpoena can be issued against any journalist. We started this process in 2024, and the NDPP did give authorization, and Section 205 subpoena was issued for the footage, but there's been toing and froing with the legal representative of ENCA, but about 2 days ago, my Lord, they undertook to furnish the state with the footage, and we also want to take Brigadier Gininda through that footage. It's a 2 minutes footage that will not take long, my Lord, and we just want to include that, my Lord, as part of the state's request to re-examine Brigadier Gininda on that footage. It wasn't specifically canvassed during cross-examination. It's a new matter, and we seek the court's permission to, as soon as it comes to hand, to re-examine Brigadier Gininda on that footage. As the court pleases.
Yes.